Mr. Lewis, take us through the new charges today and what they mean in this case.
Well, our Attorney General was trying to achieve two objectives. First of all, he wanted to increase the severity of the offense with which the officer was charged, and at the same time increase his prospects of winning a trial. So he charged basically a second-degree felony murder, that is a commission of another felony assault that results in an unintentional murder. So it relieved him of the duty to prove intent. The second thing he wanted to achieve was to, of course, charge the other officers. And the problem he faced was, in order to bring someone in under aiding and abetting, you've got to share the same level of intent. And by framing this as an unintentional killing during the commission of a felony, he could bring in the other officers, charge them with this crime without having to prove that they intended the death. So he achieved a number of important objectives.
And Attorney Lewis, there's some difference in the language in these criminal complaints that were issued today. In the first one issued by the county attorney, they actually used the phrase at a certain point that Mr. Floyd was resisting arrest earlier in the process. That phrase does not appear in any of the descriptions of what happened in these new legal filings. These filings seem to have a somewhat different tone. Did you detect any significant differences that way between the two?
Well, I detected each of these individual complaints focuses on the actions of the individual officers. So the difference in tone is one of highlighting what the other three officers did or did not do that aided in the commission of the assault and resulting in Mr. Floyd's death. So there are going to be those nuances. What is pretty apparent, though, is that Mr. Floyd, there was some initial resistance at the beginning of the encounter, but there can be no plausible claim that there was active resistance once he was put prone on his face down in the street.